Did you know that when we go ahead and bring a medical malpractice case, an accident case, or even a wrongful death case, we don't have to show with 100% certainty that what we are claiming is true? Did you know that? Come join me for a moment as I share with you exactly what this is all about. Hi, I'm Gerry Oginski, a New York medical malpractice and personal injury attorney. I'm waiting in the car here for my wife, and now I have a few moments to share with you about the standard of proof that's required in these civil lawsuits in New York. So now, what's all this about? All right, when we go ahead and bring a lawsuit claiming, for example, that a doctor was careless and caused you significant harm and injury, when the case gets to trial, we don't have to convince a jury that you are 100% right that what we are claiming is true. That is not the requirement in order to establish that you are entitled to a verdict in your favor. Instead, the legal term is we have to show by a preponderance of the evidence that we are entitled to a verdict in your favor. Now, what does that mean, preponderance of the evidence? Well, in these civil cases in New York, we only have to show that we are slightly more likely right than wrong than what we are claiming is true. Now, what does that mean, slightly more likely right than wrong? So, for example, if we use the scales of justice, right, and now they are equally balanced, 50-50, if the jury can't decide who's right and who's wrong, guess what? We will lose the case. Why? Because we are not slightly more likely right than wrong. It is evenly split, 50-50. If, however, we are able to tilt the scales ever so slightly in our favor, just a tiny little bit, that is sufficient for the jury to conclude that we are entitled to a verdict in our favor. And that is the standard that's required for an injured patient bringing a medical malpractice case. We don't have to show with 100% certainty that what we are claiming is true. So when our expert gets up to testify, we don't ask whether they are 100% certain. We ask, doctor, do you have an opinion with a reasonable degree of medical certainty that what you are claiming is true? That is the standard. When we pick a jury, it is critically important to make sure that the jury recognizes and understands that we don't have to show with 100% certainty that we are right. That's not the standard. And if they believe that that's the standard, well, I'm going to argue that that particular potential juror is not the right one to sit on our case. Because ultimately, the judge will explain what the standard, what the burden of proof is for this particular case. And we cannot go ahead and actually explain in legal terms to the jury during jury selection what that burden of proof is. So instead, we use an example such as, do you realize we only have to show that we are slightly more likely right than wrong than what we are claiming is true? And here's another example. So let's say it's a football example. So now somebody running with the football toward the end zone to score a touchdown. They don't have to go all the way into the end zone to go ahead and score that touchdown. They only have to get that football slightly past the end zone line in order to justify a goal for them. Same thing in our particular type of case. We only have to show that we are slightly more likely right than wrong than what we are claiming is true. And if we can do that, now we are fully entitled to and fully justified in receiving a verdict in our favor. So why do I bring this up? I bring this up because so many people think that the standard of proof in a civil case is the same as in a criminal case where we have to show beyond a reasonable doubt. No, that is not what happens in a civil case. The burden of proof in a civil case is much, much less. So don't think for a second that they are the same. And I realize you're watching this video because you likely have questions or concerns about your own matter. Well, if your matter did happen in New York and you are thinking about bringing a lawsuit, but haven't done so yet because you still have questions that need to be answered, what I invite you to do is pick up the phone and call me. You know, I answer questions like yours every single day, and I'd love to chat with you. You can reach me at 516-487-8207 or by email at Gerry, Gerry, at Oginski-law.com. That's it for today's video. I'm Gerry Oginski. Have a fantastic day.